I think Ms. Thierry has a question.
Yes, ma'am.
Yeah, so just in terms of just a practical application, just for the benefit of all of us here and people listening, I want to ask you just a couple of questions in terms of real life situations.
Absolutely.
For example, if a woman is married and she's the victim of, for example, domestic violence for several years, would your position be that she filed a divorce saying she is the victim of, and let's say it's even, let me change that one, let's say it's mental abuse, emotional cruelty. What is your proposal to have her do if she would like to get a divorce from this man that she's married to? And from the due process standpoint, are you saying that she would need to prove beyond a reasonable doubt in a court of law that she's the victim?
No, not beyond a reasonable doubt.
Well, at some point, preponderance of the evidence, preponderance of evidence,
yeah,
that she is the victim of mental abuse or emotional abuse.
Just like it was from 1848 to 1970. And see, one of the good things about Representative Krause's bill is those things are going to be redacted, but you still have the burden of proof. Anytime I go into court as the plaintiff, I have a burden of proof for my client to win, and the defense has the ability to show I don't, or to come up with some type of legal bar. But no, that would be the same as it was from 1848 to 1970.
Okay, so at the end of the day, would the outcome be okay if she was still divorced? Or is the goal for this person to stay married to someone that they feel they're being abused by, or they are being abused by? Or is it just to, what is, if the outcome is going to be the same?
As Chief Justice Hemphill said, reasons approved by law, where you show adultery, physical abuse, mental abuse, abandonment, those were all good grounds, and divorces were granted in Texas all during that period of time. Really, we're not changing anything. We're just simply getting rid of the due process part and going to what the law was from 1848 to 1970. It was nothing new. I mean, we got over 100 years of judicial precedent on it.
Well, I bring that up because I know the National Organization for Women was behind a lot of the changes for the divorce laws back in the time period you're talking about in '69, early 70s. And a lot of it had to do with women being battered and fleeing and being in very, very physically threatening situations.
But divorces were granted in those cases and should have been.
Well, and that's my question.
Yeah. Representative Thierry, I thought you had an interesting point when we talked about the 60s and 70s when these no-fault divorce bills were coming into place, and one of the leading groups was the National Organization for Women because of what they thought it was going to do. Did you know that just a couple decades after that, Betty Friedan, the president of the National Organization of Women, came out and she said no-fault divorce was a mistake. It had a lot of unintended consequences than we thought. And even Ronald Reagan, who instituted the first no-fault divorce in California, years later told his son Michael, he said, you know what, one of the biggest regrets of my public life was signing that no-fault divorce bill. Because it starts with good intentions. There's a lot of reasons that it was put into place. It was meant to make the system less acrimonious, less hostile, but we've seen a lot more negative consequences come from it than positive consequences. It starts with good intentions. There's a lot of reasons that it was put into place. It was meant to make the system less acrimonious, less hostile, but we've seen a lot more negative consequences come from it than positive consequences.